Well, hello everyone. Yes, it's late. I know. I've been doing these little late night hangouts, but I had a little power nap earlier, so I got a good like 6 hours of solid nap time in, and I had some coffee. Actually, I'm still having coffee, but I figured I'd like just stream for a little while tonight, talk to you guys about these filings that I mean, I can't say I can't make heads or tails of them, but I mean, there's just some issues with them that I'm not quite familiar with because I'm not a lawyer, but I've listened to other people do some commentary on them. But I kind of wanted to get your guys' maybe feedback on it and see what you guys think. Because going through these filings from the 14th on the Katie Joy lawsuit with 7M, the only thing I really got out of any of it is basically the lawyers are being very snarky with each other. Mostly, obviously, the 7M lawyer. I mean the Katie Joy's lawyer, not so much Amber, obviously. Amber, I think her filings are just on point. They're to the point. They don't get into the mire and the muck and the dirty sandbox that it seems that Graham is going into. But at the same token, there's obviously a lot of confusion on the filing dates, and you get one group saying one thing, another group saying the other thing, and then when people go into the filings and they say, well, okay, well, let's actually look at the dates, they don't seem to match. At least in my opinion, they're not seeming to match what Katie Joy's lawyers are saying, and they seem to be using some very piss poor excuses to kind of get out of what's going on. So this is kind of my take so far. And as I go, I'm not going to read through these. I know everybody else has read through them, so I'm not going to read through this. This is going to waste everybody's time. I just want to give a brief synopsis. And if you want to join, the link to join is in the video description and the live chat. Actually, I think I just put it in the live chat. So it's in the live chat if you want to come in. Hi, Autistic Shill. Good day. How are you? And as Frida, pleasure as always. It's late for you. I know you're staying up. Thank you. I'm not a lawyer, and you're without one. Yes, I still have a lawyer, but you don't have a lawyer because you're without a lawyer. But let me know what you think without a lawyer. I think you probably have read these by now. I'm pretty sure probably Autistic Show has been enough hangouts where she has seen them. And kind of give me your feedback on them because, like I said, I'm not going to be going through them in any kind of real detail. I just don't see the need for that because it's already been done. But I mean, just like this particular one I have on the screen, just like starting off, I mean, it just starts off so snarky. And again, I don't mind lawyer snark. I mean, that's what Emily D. Baker calls it, and that's exactly what I think it is. And I think some snark is good, but this is a little bit over the top, especially when they're making the mistakes. The defendants are making their lawyer screwed up royally, and then they try to just kind of like say no big deal. Their excuses seem to run all over the place from, oh, well, my mother-in-law died, my father-in-law died. They couldn't get the story straight there. You never told us you're going to do a default judgment like they have to. And I still think for some strange reason, it seems like the court initiated that default judgment. And I don't know why it seems that way. But it just, the way I'm reading it, it seems like for some reason the court initiated a default judgment procedure. And I don't know how that usually works because normally the plaintiff would have to say, hey, look, they missed a filing date. And again, I'm not a lawyer by any means. But when my experience with the legal cases, the lawyers have to say, hey, you missed the filing deadlines. Therefore, any opportunity to put up a defense for what we're claiming to be the case, you've waived by not filing a prompt reply. Therefore, we're going to file a default judgment. Now, everybody knew in my case, the default judgment, judges don't tend to like default judgments. They like to see the case arbitrated, from what I understand. But, there's so much things going wrong in this particular case. I don't know why a judge wouldn't, and maybe at this point, not sign the default judgment, because what is there to gain by having a trial when there's just so much screwy and buffoonery and shenanigans going on? I think so. It starts off. You guys can you guys read that? Is that too small? Can you guys see it? It just starts off with a lot of snark. It says, once again, plaintiffs make careless errors of fact and law while seeking the most draconian measures of against an excusable error by counsel for defendant. Well, okay, obviously a lot of hyperbolic language in there. And again, I'm not against the snark. I'm not even saying that I have a problem with this. It's just that they made the mistakes, though. I mean, that's what I find to be funny. They claim it's excusable error. The judge has not ruled upon that. I don't find it to be excusable that they missed a deadline, and the reasons they gave don't make sense by why they missed the deadline. I don't know why they think that a lawyer having their family matters, in which case there was two different stories. Graham had said that the reason why they missed a reply on the motion for was it on the motion of discovery or to compel? Was that what it was? The reason why they missed it was because his mother-in-law passed away. But in another place, he said father-in-law. So there's a little bit of confusion there. But it wasn't Graham that signed the response. It was the other one, Hendrickson. Is that her name? So there's multiple people in that office. So why would it matter about his personal things if he wasn't the one actually doing the reply? It wouldn't. It just seems like he's just maybe coming up with an excuse because to cover his own competence or something. But I don't know how the judge is going to look at that, obviously. We will know on the 21st. There's a hearing on the 21st. No, I'm sorry. Yeah, it's on the 21st. That's what it is. So if you haven't got the information to log in for that, I believe is it 1:30 Central Time, if I'm not mistaken? Again, correct me if I'm wrong on my times. But it is on the 21st. I have jury duty that day. Hopefully I won't get called in. Not that I'm avoiding any kind of jury duty. I'm fine with it. I've had it going before. But, I would have to work that night. So it's just like, yeah, jury duty all day and then working all night would be. But you usually call on the weekend, right? You say, hey, you call on the weekend, you put your number in and they say, yeah, we don't need you for this week, but be on standby, or we just don't need you at all. That's the way it usually works. I got a high group number. So normally the higher the group number, the less chance you have to come in from understand. The low group number is what they need to basically have come in if there's a case, and then they have the standby and the alternates. So hopefully I won't have to go. I really rather not this year. But again, it's a civic duty, and if I have to go do jury duty, I'm fine with that. But it is on the 21st, which would be the same day that the 7M hearing is, so the judge can rule on this stuff. And I think it's also the same day for Todd Chrisley's sentencing, if I'm not mistaken, isn't it? Is that the same day? I believe it is. So, anyways, all right. So, it goes on to say, here plaintiffs have, one, filed an untimely response to defendant's motion to compel. Again, for some reason, I thought the court filed that the default. But anyways, it wasn't untimely. Matter of fact, they had been saying that. Okay, so to kind of take a step back, both of them kind of missed a deadline of sorts. Both of them had been corresponding. The two lawyers have been corresponding, and basically kind of doing a lot of things informally rather than through the court record, which I don't think is unsubstantiated. I think it's pro forma. But then the judge came back and wrote on both of their letters saying you have to go through the court to do this. If you want to extend the deadline for discovery and you want to make a trial longer or anything like that, whatever you want to do, you have to actually put it in formal writing to the court. That's what the judge wanted. It wasn't just 7M's attorney that needed to do it. It was Katie Joy's lawyer that needed to do it too. So both of them were admonished by the judge, if you want to do this, you have to do it through the court. 7M's lawyer then did it through the court. Her lawyer, from what I understand, did not. And so I don't know why they would say it's an untimely response. And again, they have to show that an excusable error, which they have not done. But the excuses they have are pretty bad. But then they say made absolutely no substantive arguments explaining why they should not be required to respond in a time to timely serve discovery. Well, again, Amber, which is 7M's lawyer, said, look, we want a ruling on the protective order of the information on the discovery. In other words, they were afraid that the discovery motion would give Katie Joy information about critical operations about 7M, including bank records, financial records, personal records that she could use to her own malicious intent, which she has done multiple times. And Amber points this out to the court. This is nothing new with Katie. Katie is known for doing this. And according to sources, supposedly she has been working with some kind of deal with Netflix, which is going to explode, I think, just spectacularly. I can't imagine Netflix ever working with somebody like Katie Joy. The ramifications and the repercussions would just be absolutely immeasurably. Uh, just it'd be fireworks. I think they've really been warned on that. But by that measure, they had said, "Hey, look, Katie Joy has a history of releasing personal information, doxing people, and using this kind of information to her advantage. We want a protective order on it. We want to make sure that anything that's given to the client cannot be released. And basically, it's between the attorneys." And 7M's lawyer was quite fine with that. They're like, "Look, we don't want this information out, and we want the judge to rule on it before we give you anything." Graham said, "No, you can't do that, according to the rules of general procedure." But they think they got the rule wrong. But even still, they wanted a ruling on it, which I think they're entitled to get. I mean, if I was going to turn over personal information that could be very harmful to a business, to my business, or to me personally, I would want to make sure there's a ruling on it before I give it to somebody who's so dishonest as Katie. I think that just makes sense. There's precedent for that. But they're like, no, we want all this information. Well, they're like, no, we're not going to give you anything until the judge rules on it. There's a hearing on the 21st. I think that's a wise move by 7M's lawyer. And so it was actually, I think, wasn't it Graham that basically said initially they weren't going to give any initial responses until they ruled on the motion to dismiss? Wasn't he actually the one that said, "Hey, we have a motion to dismiss. We're not going to give you anything until the judge rules on it, because if the judge dismisses on it, then it's all kind of moot anyways." And people are like, no. According to the rules, you have to give it regardless. So, but in this case, I don't think the 7M was obligated to give them anything until the judge ruled on it. And then number 3, misrepresented the record with respect to counsel's communication regarding discovery. No, I kind of read the correspondence between them, the letters between the lawyers, and I don't think anything was misrepresented by 7M's attorney. It was pretty straightforward that 7M's attorney was saying, this is what we're doing, this is this. And then Katie's lawyer was all emotional and just basically talking about impugning his character, which was nothing that Amber ever did. Amber was impugning the character of Katie, perhaps because, Katie's dishonest. But it was never about the lawyer, and so I don't know why he made that so personal. And they go on to, and again, I'm not going to get into the specificities of these, but basically the dates. The dates, I think it was actually, the original one was like August 5th, I think they had to get something by, and it ended up being on the 7th, but then they made a mistake in the typography, and they basically put the wrong date down. But then they argue, well, that wouldn't have mattered anyways because of all the communications in the emails. It didn't matter what we put in the motion. It mattered what I put in the email, but the date in the motion was actually, I believe, 2 days off. And so they go on to say, most of the I love this right here. Most of the defendant's discovery requests were non-controversial, seeking information that cannot possibly be the subject of a protective order. Well, if it's not all, then some of it clearly is controversial, and which could be seeking information which can be the subject of a protective order. I don't know why they shot themselves in the foot by saying this. To me, it seems odd as somebody who likes logic, right? You have set theory. And so you have all, and then you have some. And then you have most, which is basically anything over 50%. So if I say most of the defendant's recoveries, that means that over 50%, but not all. That's what most implies. So there is clearly some controversial material that the plaintiff doesn't want to turn over to the defendant for obvious reasons, because they believe Katie Joy will misuse it. Shocker. Yeah, we all know that she will. That's what she does. She's like Scientology. She'll get as much information as she can on a person and use it against them to the fullest extent, even to the point where she not just takes that information and utilizes it, she takes that information and weaponizes it above and beyond what's in there, because she'll add her own little narrative to it. That's what she's being sued for. right? She adds all of these other things in there, which is not just her personal opinion, but she states things as fact, and then she lies about it, says she got it from some other source that she never got it from. Oh, well, I said it, but there's other people said it too. That's not an excuse. That's whataboutism. That's tu quoque. You can't go into court saying, well, yeah, I defamed this person, but this other person did too, and they're not suing them. So what? You don't have no obligation to sue those other people. And that's, by the way, that's exactly what they have argued before. They have literally said, well, all these other people were doing it too, so what? That is not an excuse to defame. And then they say, for example, some of the discovery requests seek information related to court records or property records. Some discovery requests merely ask the plaintiff to identify witnesses or others who may have knowledge about the matter raised by the lawsuit. This discovery cannot possibly necessitate a protective order. Why not? Where's the rule on that? Wouldn't that be the judge's decision to decide what is private, what information could be harmful to the litigants in the case, especially to the plaintiff, because the plaintiffs have a lot more to lose here? Wouldn't that be something that the judge would have to rule upon? What am I missing here? And they say, yet the plaintiffs have failed to respond to any discovery at all. Yes, because they're waiting for the court to give a ruling on the protective order. They know this. They've been very clear about this, that they're not going to give them anything until the judge says, yeah, I'm going to rule on this, and it's going to be sealed. And it won't be allowed to be given to the client. Unless it's absolutely needed to be, but it's usually between the court, the lawyers, that they have this information, and then they will decide, if Katie Joy is privileged, should have privilege to observe something, in the court discovery findings. So, and then they say, yet plaintiffs have failed to respond to any discovery at all. For whatever reason, they believe they should be entitled to bring a lawsuit against defendants while hiding defendants any information that would permit them to formulate a defense. Well, I do say that to a point, right? I mean, it's kind of hard to know what your defense is going to be if you don't know what the opposition has. I do get that. But at the same token, their clients defamed people. Their clients said that they were trafficking human beings. What kind of defense do you need? What documentation and discovery do you need to formulate a defense from that? I mean, a good defense is, well, my client is mentally unwell and shouldn't be held accountable for her actions. That's a good one. But what defense do you have to say, oh, my client defamed your client, but, who cares, right? Who cares? Matter of fact, one of the defenses they're running is basically arguing that Katie Joy has freedom of speech to defame people. No. There's nothing in the law that says you have the freedom to defame people without repercussions. That's not part of freedom of speech. It's more than just reporting. It's not even just gossip. It is pure outright fabrications that have affected the business of 7M. In fact, Katie Joy had torturous interference, where she interfered with the contractual relationship between them and the LA Clippers, which has cost them a lot of money. So that needs to be adjudicated. I mean, that's something that can be adjudicated. Did you contact the LA Clippers? Well, yes, she did. Did she have false information that led to the termination of the contract? Yes, she did. Did it affect financially 7M? Yes, it did. I mean, what do you need in discovery to really formulate a defense for that? Now, again, I do agree with them. It is hard to formulate a defense unless you know what the opposition has. I'm not faulting them for that. But the same token, they already know they're not going to get anything until the judge rules if they're going to put it under a protective order or not, which I think is highly likely, knowing the information would be used in a Netflix documentary if it goes through, or even for Katie's own personal usage to go slander people, because that's what she does. Hi, Mia Nova. How are you tonight? Good to see you out there. It's been a while since you've been, in my live chat. And by the way, like I said, the link to join on StreamYards is in the top. Please come in if you'd like to add to this. If you've been watching like some of the other channels, go through this again. That's why I'm not like going through any great detail, because it's been talked about, ad nauseum today. But I mean, I had my own little views on it. And then it says, it may be that the undersigned counsel at some point in the initial motion papers confused the date discovery and was served with the date that the plaintiffs brought the motion to compel. Now, the undersigned counsel, I thought, was this. This is Jennifer Moore and Graham Martin. So are they saying that they were confused about the filing date? Because it seems to be the case, because in one of the filings, they got the date wrong. They put October 5th. It was October 7th. However, that would be a typographical error, which, okay, yeah, it would just be like they made a mistake in the filing. That happens, right? The courts know that typographical errors happen in filings. They happen in my lawsuit. They're minor, but they do occur, but you have to look past that. It's not so much the letter of the law kind of stuff. It's not like a contract that's whatever in the contract or the four corners. We call the four corner rule, that anything within the four corners, that's what you go by. When you're doing these motions, it's not as formal as that. So they know that little typographical errors, dates might be off and things of that nature. But, they say that would be a typographical error. They got the date wrong. That is more than made up for by the sheer number of times the memorandum of law states that discovery was served on October 5th and that the plaintiffs brought their motion for protective order on October 26, 2022, which they were allowed to do. They had 14 was it 14 or 21 days? I don't remember. One of them was 14, one of them was 21. It doesn't matter. We're not lawyers. Who gives a crap? We know, though, there's a certain time to respond after that filing. And they didn't respond past that. It was a late filing. And so the motion, the protective order was filed October 26th saying, hey, we will not release to you any discovery until the judge rules upon this, which I think they're able to do. I don't see a problem with that. And let's see here. Again, confusion with the dates. I'm not going to go on the timeline there because there seems to be a lot missing from that timeline. And that's one memorandum. This one's interesting. This was the affidavit of Amber. And Amber seems to be on the ball. I like Amber. Yes, I've talked to Amber, so she's very congenial, and she lays it all out here. Because Graham, I guess, was saying that his well, oh no, was it Amber that said that Graham had impugned her character? I don't even remember. It's just like it was just going back and forth, but there was something in here that I found really interesting. Let's see here. Graham says, "Good afternoon, Amber. I read all your correspondence, and we understand you and your client's positions on the issues currently before the court. We are the opinion that the proper time to either ask us to stipulate extended scheduling order or deadlines, or to make a motion, was to do so prior to the deadline expiring. But they had been talking about it, but the court is the one that said, in order to extend the deadline, you must do it through a motion," which, from what I understand, 7M decided to do, but not Katie Joy's lawyer. They also say, "We understand that your clients think some of the information we requested is potentially sensitive," because it is. It's bank records. And the way that Katie Joy has, slandered 7M, that information could be very harmful to their business. That information was also directly relative to the claims your clients have made in their suit, so it is necessary and needs to be disclosed regardless of the existence of a protective order. Well, that's up to the judge to decide. If the judge says, I'm not going to issue a protective order on it, you have to disclose it, then I guess that's what 7M has to do. But that's up to the judge. Let's see here. I love this one right here. It says, alternately, should your clients prefer not to engage in discovery in this matter, they can always choose to dismiss their case with prejudice, at which points their discovery obligations will cease. Yeah, that's going to happen. What planet is that happening on? Clearly, 7M does not seem like they're going to dismiss this. They have an excellent case against Katie Joy. As I said, my lawyer went through it, spent money to have him go through it, and said, yeah, 7M is going to have a windfall, basically. And so here you have Graham Martin going, oh, if you guys want to dismiss it. No. And then he says, my client remains disinterested in proposed stipulations. We're already working on the answer, and we'll have one filed next week, which they didn't file on time, if I remember correctly. I didn't see a directive as when the court expects to be filed, so absent such a directive, we would just create and file it with all deliberate speed. But like I said, I think they missed that filing. What else is in here? Yeah, you guys can see it on the outside. Okay. I like this one too. This is good. This is good, guys. He says, I swear, I could tell you right now, every lawyer that had dealt with Graham was not impressed by him. I'm not making this up. I have the correspondence obviously with my lawyers. They're not thrilled with him. And he says, a number of times since the case began, you have asserted that we agreed that neither party would talk about the other publicly during the pendency of the case. But I've reviewed our email correspondence, and the only thing we have agreed to do was not disclose online contact information or the parties or their attorneys, which obviously have been fully disclosed now. If you have a different written agreement than what I've just described, will you please and copy it of it to me so I can review it and advise my client of it? I don't think any such things exist, though I am unsure of the continued insistence that my client is violating it. So I don't have it here. It's not in here somewhere that I have found, but I can imagine that when lawyers communicate with each other, they probably try to say, hey, look, we don't want our clients talking about this stuff. When you're in a defamation lawsuit, you probably don't want your client making further defamatory statements. I'm not a lawyer, but I don't think you have to have a law degree to have common freaking sense. Right? I mean, they go on to say that Katie Joy has continually streamed about 7M and further defamed them. Why would a lawyer want their client to do that? So I can't see it outside the realm of possibility that they have communicated and said that, and maybe it was on the phone or something. I don't know. And they say, hey, look, we agree that neither party will talk about the other publicly. I think that's probably something that I could definitely rationally believe that has happened between them at some point, whether it is in writing or on the phone. But even if it hadn't, don't you think that's kind of common sense? You know, I mean, it would be something that was be talked about, and they say, okay, my client has declined to not to no longer further talk about your client. Okay, that's fine. Let the lawyers know. Like on my case, when I told my lawyers I'm going to continue to talk about Katie Joy, they said, okay, we're okay with that, knowing the uniqueness of the situation, so to speak. They realized that the case was kind of a unique because of they're dealing with somebody who is clearly dishonest and clearly will lie on affidavits. I mean, this is fact in evidence. Katie Joy lies on affidavits. I will prove that till the cows come home. There are so many lies in her affidavits. It's just unbelievable. And these are demonstrable lies. These are not just a matter of opinion. These are not just subjective things like, oh, Steve likes vanilla over chocolate, right? These are just demonstrable lies and errors that she has in her affidavits. I mean, hell, in one of her freaking filings, she said that I lived in Elk River, Minnesota. Come on. She knows I live in California. That had to be some deliberate reason why to tell a judge that I lived in Minnesota to make it appear that I lived closer to her than I did. That had to be deliberate. There is no other excuse for that. That was an outright bull-faced lie to the court that she said that I lived in Elk River, Minnesota, where I've never been to before. So yeah, it is clearly demonstrable that she lies in her affidavits. I have a whole videos on that. So it would make sense that Amber would reach out to Graham and say, hey, look, we don't want our clients talking about each other, especially when it has more harm to 7M than it would be to Katie, I think. And then he's like, well, you've asserted this, but we've never talked about it. I find that to be, doubtful, dubitable, to say the least. I mean, can you guys imagine having two high-paid lawyers that have not talked about if their clients are going to be able to discuss each other during the course of the proceedings? I don't know. I find that to be odd. So, here, and this is golden. She says, Mr. Martin, and by the way, notice the difference in if you guys go through these filings, notice the difference in tone. The tone of Graham is really emotional, really charged with and laden with these very hyperbolic and very emotionally laden terminologies. While Amber's matter of fact, boom, this, and this, and this. She's not messing around. She's not interested in having a pissing contest with Martin. She is like, this is what happened. This is the way it is. This is, what we want the judge to do, and keeping it about the case, which I think good attorneys should do. I think they should leave their feelings out of it, for the most part. I mean, obviously, there's some cases where you do get emotionally invested. I mean, obviously, with the Johnny Depp and Amber Heard case, those lawyers had absolute reason to be emotionally invested. There was some snark there. I mean, when Amber was being cross-examined by Camellia, oh my God, that was brutal. Absolutely brutal. And one of the best cross-examinations probably of all time that would probably be talked about in law school for many days to come. She was quite snarky with Amber because she has some emotional investment there. And that's fine. Again, I'm not criticizing people having emotional investment, but if you just read the tone of the emails, this is how Martin is. He's not a matter-of-fact kind of person. And I think he realizes that his client is a complete, dishonest, evil, manipulative person, but he might be too. Maybe that's why they get along. I don't know. I mean, I understand a lot of people have to defend people, and a lot of people have to represent people they may not like, but that doesn't mean you have to be like that person. But for some strange reason, Katie Joy has a knack to finding people just like her. She seeks them out and finds them. Sociopaths attract sociopaths. So it doesn't really blow my mind to think that Graham is a lot more like Katie Joy than probably people realize. But again, I'm going to give him benefit of the doubt. But this is epic. She says, this email is being sent as an attempt to meet and confer regarding several issues regarding the 7M without a crystal ball litigation. I have been informed that your client went on another social media spree where she spread false information about my clients and their associates last night. On one such post, two of the dancers she talked about in the post explicitly told her that their post was false, and her reaction was to taunt them and state the information was, quote, her opinion, instead of taking down the false information. I have also been informed that your client has a documentary deal with Netflix and that she has been advised to post about my clients in an effort to promote that documentary. Wow. That, I think, is the most mind-blowing thing in this entire document. I personally think that stands out more than anything because Amber's pointing out that Katie Joy is still going on social media, lying about her clients, creating more defamation, harming their business, which no judge is going to want to see. Again, I'm not a lawyer, but have some common sense here. A judge is not going to sit there and go, oh, yeah, I see your client there, Mr. Graham, is still going on social media talking about Amber's client, or how do you pronounce her last name? Miss, I don't want to butcher her last name. I just don't. But I'm just going to call her Amber. So I can see that your client is still defaming and making these comments about Amber's client. Why is that, Mr. Martin? It's to promote a Netflix documentary where she might use the information that she gets from Discovery in that Netflix documentary. Protective order granted. That's what I kind of see happening. That's what I hope happens. That what seems to be would be a rational adjudication by the judge. If the judge says, "Hey, your client's talking about having a Netflix deal with that could actually harm the clients," you have to look at the harm. The judge has to say, if this goes through, if you get discovery information that can cause damage to one of the parties, you have to take that into account. And there's a test for that. So I was just laying it right out there, boom, to set Martin. Hey, your client's still doing this stuff. And where's Martin? Where's Martin going, hey, Katie, stop it. Not that, she would listen to him. But, if your client is out there making things massively worse, then it's either because you have not, explained to them fully the ramifications of that as an attorney, you're condoning it, maybe, to prolong it, or you're just incompetent. I don't know. Maybe there's some other options. I'm not saying that's a true trichotomy, but those seems to be the three main issues or the main three reasons what it could be. And she just says, previously we discussed via email that neither of her clients would talk about it on social media. I don't see that in here. I did look. Did you guys see where they did discuss that? Because she does say email. She doesn't say phone here. But I don't recall actually seeing that email where they did discuss this. At least she didn't include it. And there could be some reasons for that, right? there could be emails where it's not just correspondence between the two lawyers, but there could be information about their client that if that email is made public in the record like this, it could be violation of attorney-client privilege. So there could be other emails out there that are not filed with the court because in those emails, there's privileged information. Now, obviously, they could redact that, but I don't know. In fact, like I said, if you guys have any input on that, please let me know. So, and she says, and we will not be responding to your discovery request or issuing our Rule 26 disclosures until either a protective order is issued by the court for the information disclosed by my client. She's very clear about that. That needs to be ruled upon. So she and they did just that. They filed for the protective order, and they're still waiting for the judge to rule upon that, and that'll be on the 21st, if I'm not mistaken. Graham does says, received, I will communicate with her about those items. Good luck. Presumably you have had the same conversation with your clients already regarding online information. Yeah, most attorneys will tell you, if you're in a lawsuit, shut the hell up. Again, my attorneys were well aware of what I was saying online. They just didn't think it was a problem. And I told them exactly what I was saying. They're like, look, you have every right as a First Amendment, in your First Amendment to discuss. And obviously, you need to help raise some revenue for it, your lawsuit. But they're like, just make sure you don't say anything defamatory that you do not have evidence for about Katie. I'm like, oh yeah, well, they've read everything I had about Katie, so they know everything I had. They knew everything I had was documented by evidence. I'm sure by now Graham knows his client is dishonest. If not, he is absolutely incompetent. I will state on record, if Graham has not realized that Katie Joy is absolutely dishonest, he is himself either incompetent or dishonest himself. I don't see any other possible thing it could be. I'm sure there probably is. Again, I'm not trying to make a dichotomy out of it. I'm not trying to say that these are the only two possibilities, but those two seem to be the most prevalent. If you guys have any other things it could be, let me know. I mean, what do you think it is? Do you think Martin knows that his client is dishonest? I'm curious because, Kyle's lawyer knew that he was dishonest. Why? Because he lied to the court. He lied to her. That's why she left. That's why she invoked Rule 1.16 B14, was it 147 and 10? Because she said, hey, my client, he lied to me and I can't properly defend him or represent him because to do so would break attorney-client privilege to the court because I know information that is false and I cannot have my client lying to the court. Which seems odd here because if Graham knows that Katie Joy has lied in her depositions, doesn't he have an obligation to recuse himself if he knows that Katie Joy is lying to the court? Or he's just going along with it? Anybody got any ideas on that? I mean, if he knows that she has lied, would not he have some obligation to go, hey, look, I cannot have my client perpetuate a lie to the court because that's fraud? I would think so. But again, I'm not a lawyer. Let's see what. Oh yeah, so this is. And then it goes in the actual exhibit of what's, I guess, supposedly a advert for the Netflix possible documentary. And there's some misspellings in here too, and I think it clearly was written by Katie. I would be willing to bet it was written by Katie. It sounds like Katie. The grammar's like Katie. The verbiage is like Katie, and then it's just like, how do we get them out of the cult? So she's still promoting this dance group as a cult with absolutely no evidence. She has not provided the court anything yet that show that anything she's put about the 7M dancers is true, and she's so intricately trying to relate them to the church because Robert Shin, obviously is the head of the Shekinah Church. Is that how you pronounce it? But that's irrelevant. That has nothing to do with the 7M business. They're independent of each other. Let's see here. She has some spelling errors here, but then she's talking about her, she goes in to talk about, his past his lawsuits and things of that nature. So it's clear to the judge, I would think, would be that if Katie Joy got her hands on any personal information like this, it would be used in the documentary, which could be harmful to 7M's business. Thus, the need for the protective order. The team, Katie Joy. I don't know any of these other people. The team, Katie Joy. Come on, who the hell's promoting this? Who's This is just complete nonsense that she thinks because she's stating this stuff as an opinion, she's not liable for slander when it's affected their business. Not how it works. You don't get away with lying about a corporation, a company, or business affecting their business, having torturous interference, and affecting contractual relations merely because of opinion. You don't get away with that. That's not how it works. Okay, and what else we got in here? What was this one? Let me see who's filing this one. Oops. Yeah, so Amber has argued. She says defendants in this case have both failed to serve a timely answer in this lawsuit and support its rationale for failing to serve a timely answer. Although it's plaintiff's contention that the defendants are in default because they have filed a default motion to grant what's called a summary, not summary judgment, a motion of default judgment, right? I do not have a reasonable defense to the lawsuit. Should the court allow the lawsuit to continue? Plaintiffs respectively request that previous discovery motions to be granted. So I think Amber's absolutely right. It doesn't appear that 7M has a reasonable defense at the moment. Now, they came back and said, well, how can we have a defense when we haven't gotten discovery? Okay, I will grant them that. But they haven't even had any preliminary defense other than the dog ate my homework kind of stuff. Oh, my mother-in-law died. Yes, we missed a deadline, but hey, so did you. Or, we don't feel we have to do this or do that. Or it's free speech. That's what they're going by right now. Their defense so far is that Katie Joy has a free speech to defame 7M. But that's not a reasonable defense to the lawsuit. So I think Amber's absolutely right that the defendants are in default and they don't have a reasonable defense. So why continue it? What is there to gain? And that's something that the judge will have to obviously rule upon. So, for the default judgment, defendants have failed to provide reason for their failure to timely answer this lawsuit. Their excuse was that Graham's mother-in-law or father-in-law, depending on what you read, had passed away. I would think that if you're going to try to tell a judge why you didn't have a timely response, you would get it right, whether it was your mother-in-law or father-in-law that passed away. I think that's pretty important, don't you think, to have your story straight? But I'm not BSing. In one of the filings, Graham had said it was his mother-in-law, and in another filing, he had said it was his father-in-law. Strange. And I'd like to see how he corrects that in front of the judge. I would like to know his excuse for that. But that's not a reasonable excuse because there's other people in the law firm, and it wasn't Graham that did the answer anyways. It was the other lawyer. She signed it. So it had nothing to do with his family matter. So why would his family matter be an excuse for not filing a answer on time? That's why they have the default judgment motion, because the defendants did not file on time their answers. This is established. So when Katie Joy said she says that they didn't miss a deadline, she is lying, like demonstrably lying. Amber's straight up saying you failed to provide a reason to timely answer this lawsuit because they didn't file on time. And that's why Graham has all these excuses. So why is Graham having excuses that they didn't file on time and Katie Joy lying to her subscribers saying, oh, well, we never missed a deadline. You lie. You lie. Oh, my God. It's so brutal how bad, she's lying because you can go read it for yourself. But, of course, her stupid followers are never going to read this stuff. I mean, she's milked them dry. She's bragging she's bought an $80,000 custom BMW with their money. The money that's supposed to go to her son. Oh, my God, I can't afford medicine. Insurance is so high. Send me money. Oh, I'm going to buy this $80,000 BMW with it, suckers. Oh, my God. I swear, I'm blown away how dumb her followers are. To give that woman money, I mean, the queen of grifting. And it is black and white in the documentation. Not just in this court case, but in so many other court cases, she has lied. She lied in my case. She lied in the Toddy Westbrook case. Every case she's been in, she has lied. And then she's like, grifting for money, saying, I need it for my child. And, medicine's so high and insurance. My husband's going to lose health insurance. Oh, I'm going to buy it to $80,000 BMW while I'm looking at $1 million judgment against me. Does anybody not see a problem with this? Is it just me? I don't think it is. I know you guys don't. I know you. I know you guys do see a problem with it. I know my audience are not full of idiots. When you are telling the people you need money for something and then you go buy an $80,000 freaking car, come on. I mean, this was the same woman that said she needed $10,000 to fight my request for a hearing in our lawsuit that she had already paid for on a fixed retainer. What do you need? Come on, $10,000. Come on. I'm like, oh my God, what a grift, man. I told you the most expensive purchase I've had all year was $100 that I spent for a Chromebook. And an inexpensive Chromebook at that. I mean, the Celeron processor, but the only thing I wanted it for is word processing, Facebook, Twitter, and basically that's it. I have no interest to play games or anything else on it. It's 11.6-inch monitor, and it runs spectacularly well, actually, for what it's designed for. It's a Lenovo, what is the model? N4020. And I got to tell you, I like this little Chromebook. It is really, really fucking nice, man. It's portable. The battery life seems to be good on it from what I read. I haven't tested it out yet, but it's exactly what I need it for. So I'm not going to spend $2,000 for a high-end laptop just to brag about it and go, oh, look, man, I've spent $2,000 or $80,000 in her case. No, I'm frugal as hell. And when I splurge, it's still frugal. And so, yeah, I only bought a $100 laptop because that's all I need. But she's all bragging about buying an $80,000 freaking car, So, and then she says, defendants have failed to provide case law which supports the contention, or its contention that a plaintiff's failure to provide discovery can defeat a motion for a default judgment based on a defendant's failure to timely answer a lawsuit. Yeah, so the defendants are saying, hey, you shouldn't have a motion for default judgment because we didn't do the discovery right, or we didn't file this on the discovery. But why is that relevant? What does the discovery have to do with the default judgment? The default judgment was because the answers were not filed in time. The response, the reply, whatever they had, was it 7 and 14? Was it 14 days or 21? I don't remember. But whatever it was, it doesn't make a difference. They did not file on time. They missed the deadline, which means that they have a right to file for a default judgment. And again, I don't know why I think that the court did that. Somebody help me with that. Does anybody know? Was it actually Amber that did the motion for the default judgment, or was that done through the court automatically because they missed a deadline? Does anybody know? It seemed to me like it was automatic, and I don't know why. I've never seen anything like that, but whatever. But I wish somebody out there that knew more about this case could let me know on that. But they're arguing that 7M has not, or excuse me, Katie Joy's lawyers have not provided case law that says because you have not given us discovery because you're waiting for a protective order, you cannot rule on the default judgment. Well, why not? First of all, if the default judgment does get ruled upon and substantiated through the court, then there's no need for the discovery. It's moot, right? So I think that Amber's absolutely right on that. They didn't provide any case law that said, oh, because we didn't have discovery or you didn't provide us discovery, you can't rule on the default judgment. So we'll find out on the 21st on that, I believe. They go on to say, defendant's conclusory allegation does not support a reasonable defense on the merits of the case. Defendants have failed to provide facts or law which support their contention that they have a reasonable defense to this lawsuit over merits. I agree. What is their defense? Could anybody tell me? Could somebody come in here and join me and give me in real time what they think about what it the hell is Katie Joy's defense? What is their defense other than free speech? That is the only thing that I've seen in the documents. And I'm sorry, no judge in the world is going to say, wait a minute, this is factually incorrect about 7M. This has caused irreparable harm to 7M. It continues to do irreparable harm to 7M. And it's just free speech? No. You don't get to harm a business by lying about them and call it free speech. Nowhere does that work that way. Gob says, did anything ever happen? Yeah, well, I'm still, there's still going on there, but I'm not going to get into that right now, Gob. But yeah, I mean, I just talked to my lawyer the other day. They're doing some more paperwork. It's a long process. I cannot, and with the holidays, it sucks. Jujubee says, I believe 7M filed for the default. Okay. Graham and Katie Joy didn't realize they only had 14 days to respond. So it was 14 days. Okay. Yeah, I think they said that too. Didn't they say they didn't know the rule of civil procedure, that they missed the deadline because they weren't familiar with the rules? Isn't that one of the things that Graham said as well? They thought the court would tell them when they were required to respond. Yeah, or that they would just do it through correspondence, so they wouldn't have to actually put anything through the court itself. So they're arguing that they missed the deadline because of a family emergency and that they didn't know the rule. And I think Amber gets into that here. She says, next, defendants claim they have a reasonable excuse for not answering the lawsuit timely. And again, this is not for the motion of the protective order. This is for the default judgment that she's talking about. Defendants' reasonable excuses are, I think she should have worded this differently. Maybe that's me. She probably should have said, defendant claims the reasonable excuses are, because these I don't find to be reasonable excuses. She says, defendants' reasonable excuses are, one, they didn't know Minnesota rules of civil procedure. I don't know. That's much of an excuse. Due to the attorney's Martin's family emergency, the answer signed by Miss Hendrick was not filed, which makes no sense because, again, Martin had said it was his father-in-law, then mother-in-law, or vice versa. But it was Hendrick that filed the answer eventually. So if she was doing the answers to the complaint, what's that got to do with Graham? He's not the only person in that office. He's not the one that did the answer. So what does his family emergency have to do with anything about not filing a timely answer? Help me with this, because I'm blown away by this. And then 3, plaintiffs did not give them a heads up that they'd be filing a motion for default judgment a month after the answer deadline had passed. And I'm required to, from what I understand. In what world do you have to let the other person know you're filing for a default judgment? You just do it. You say, hey, look, you missed a deadline. I'm filing a default judgment. That's what we did. That's how I got the default judgment. And then, of course, Kyle came along and said, I want the judgment set aside, lied to the court about it, submitted false evidence to the court, went to jail by not showing up for a criminal contempt hearing because he submitted false evidence to the court. So there's a causal relationship. So even though Kyle did not go to jail directly for criminal contempt, he went to court for not showing up for criminal contempt. It's good enough. It's still a causal relationship. If you had not had that criminal contempt for lying to the court, he wouldn't have gone to jail for failing to show up for it, right? God, legal stuff, right? With respect to the answer deadline, plaintiffs outlined the Minnesota rules of civil procedure, and when an answer is due following a motion to dismiss and memorandum of law in support of the default judgment. Further, plaintiffs sent numerous emails to defendants allowing them to extend their answer deadline, which they did. But remember, that's when if I remember correctly, the judge wrote on the top of it, if you want to extend any of these deadlines, you must do it through the court. She put that not only on 7M's stuff, but she also put it on Katie Joy's stuff. And Katie Joy just completely ignored that part. All she was showing that is that the judge said something to 7M's lawyer, kind of admonishing them, no, you've got to put it to the court. And she ran with that, not telling her subscribers that the judge said the same thing to her. That name shall not be spoken around here, Gob. That name is banned forever in perpetuity. So that'd be a no. Let's see here. As the counsel was given multiple opportunities to stipulate to an extended answer deadline and remain engaged via email with plaintiffs regarding this lawsuit, it is not reasonable that the answer was not served on the plaintiffs until this motion for default judgment was filed. So they were talking about, they were communicating. They have no excuse not to answer the complaint. So they filed the default judgment. So I don't think the judge is going to be too thrilled with Martin's excuses. I just don't. I can't imagine the judge going, oh, yeah, totally. You had a family emergency because of your mother-in-law. Oh, wait, was it your father-in-law? Oh, wait, it was Hendrick, the other attorney. that did the answer. So what does this have to do with you? And how do you not know the Minnesota rules of civil procedure when you're making $400 an hour? Wouldn't you think that if you're going to do a court case as a lawyer to represent your client, you're probably going to know the rules of civil procedure? I think that would probably be of critical importance. And you're telling me that out of all the lawyers in that office, none of them knew the Minnesota rules of civil procedure? None? It just strains the imagination. It is so incredulous to think that these lawyers are literally telling the judge, hey, look, we didn't know what the hell we were doing. We didn't know the Minnesota rules of the court. Oh, yeah, well, we had correspondence, but, we just didn't answer because, reasons. We thought that we were all going to do it through email correspondence rather than the court, even after the judge says put it through the court. Again, what am I missing here, people? I feel like I'm totally screwing this up because it cannot be this simple as it seems to be that Martin's legal team has screwed the pooch multiple times over and has this poorly written documentation and emails. And Amber's just going, well, yeah, but this is the law and this is this, and this. And, your client's defamed mine. We want money. We want a default judgment. We'll be happy with $1 million and go their separate ways. I don't know how else to read this. And if anybody else has read it differently, let me know. I know a lot of people have done readings on these filings today and yesterday. I've only been able to watch a handful. I've watched Aaron's, but I watched it at like 1.5 speed, and I watched part of Johnny Cochran, the lawyer thingy, what she had said. But for the most part, I'm kind of going blind on this stuff. And then she says, regarding defendant's allegation that he was unexpectedly called out of the office and that is why the answer was not filed, the attached emails and the signed answer supports a different narrative. Ooh, juicy. Attorney Kristen Hendrick supposedly e-signed the answer on September 2nd, 2022. Not Attorney Martin. Juicy. Well, I should make that a new tagline. Juicy. Kind of like moist. Probably not. Further, from September 2nd, 2022 through September 9th, 2022, Mr. Martin and attorney, I think it's Stavig, exchanged emails, several emails regarding discovery. So they were well aware of this. They were well aware in her emails that she had documented on the other form saying, hey, look, we're not going to give you any discovery until we have a protective order. That was very clear, but that has nothing to do with the answer. The answer still needed to be filed regardless of the discovery as per rules of civil procedure. Gob says you got to start back up with a new show similar to the MSS, thousands and thousands of left for. Yeah, and eventually I probably will, Gob. Right now in season's tough. And plus, as you know, they wanted me to go full time. It's that, but I want to do that too, Gob. I really do. I just have to push through certain things first. But I do have a great show this Friday on Non Sequitur. Steamy and juicy. Yeah, there we go. Steamy and juicy. Do you know what the show is this Friday? It's going to be, and yeah, I'm not even kidding here. The show this Friday is going to be Josh Brister is going to, in real time, convert Res rhetoric back to Christianity. Now, I've told Res, look, if you use fallacies to defend the arguments just like that, I'm going to call you out, Reds. You have to have an open mind. I'm not going to let him just go, nope, I don't believe you. He's going to have to put up reasons why he doesn't accept Christianity, just like I would with anybody else. I'm going to be fair and impartial as completely can. But yeah, so the show is going to be Res Rhetoric being converted back to Christianity in real time. That should be fun, right? Steamy and juicy. Pursuant to the correspondence exchange and the signing of the answer, it does not seem likely that the defendant's failure to answer this lawsuit is due to the unfortunate family emergency of Mr. Martin. I agree. Yeah, because it had nothing to do with that. I mean, again, it was the other attorney that did the answer, and Mr. Martin couldn't even get the name of the family member. Or he couldn't even get the family member who died correct. Either it was the father-in-law or the mother-in-law. It's one or the other, right? It's not both. I mean, maybe his mother-in-law became her father-in-law, or his father-in-law transition to her mother-in-law. That's possible. I'm not going to, if his father-in-law is trans or something like that, that's okay. But I don't think that's what the case would be. But I think any reasonable person would infer they didn't get their story straight. To have a huge mess up like that, to say, oh, it was my father-in-law that died. Oh, wait, it was my mother-in-law that died. That's like the dog ate my homework kind of excuse. And again, I mean, I have sympathy for the family. I'm not trying to, make light of somebody's death. Clearly, that's, all deaths are tragedies in those situations. But you think when you have a job to do, especially when you are representing a client, you're going to get basic information right. Like, who was it that actually died? So, no, and it's not kaput. I'm still going to be having at it, Gob. I still do shows every Friday, at least 3 times a month. I've got stuff that I want to do. And as Frida says, if Reds is as good as with Christians as he is with flurfers, it will be more than juicy. It'll be parade smoothie. Yes. Well, as you know, Reds was a Christian when I met him. It was actually me that kind of got him out of Christianity unintentionally. It wasn't my goal, but he had liked a lot of my videos, and we had just talked about things, and he realized that maybe he didn't have solid footing as he thought he had. And so, yeah, he left religion. And that was a long time ago. A lot of people don't know that, but I've known Reds a very long time. That is why, I will give my life for that man. He has been the one true friend that I've met online, bar none. We've never had a fight. We've never had a disagreement. I mean, obviously we don't agree upon certain things. That's just human nature. But I mean, we've never had an argument. I really think he's one of the greatest people I've ever met in my life, and I will always stand by that. He has been nothing but kind to me and those around him. And when I see people defame him, I have to think to myself, the people that are going after Reds, they just have to be shitty people. I can't imagine any person in good conscience who's not a shitty person going after Reds. So, yeah, a lot of people didn't know that. A lot, but yeah, he'll tell you. So, so we got history there, right? Because I had a major influence on him. And he's had influence on me. I respect his opinion and judgment. Again, I don't always take it, but he always knows that, dude. He's like, hey, this is my advice. Take it or leave it. Whatever. And if I take it and it works out, great. If I don't, if it works out, great. And if it doesn't work out, then I go, yeah, sure, listen to you. And if it does work out, he's like, yeah, glad you listen to me. That's what friendship does, right? Yeah. I think it's 5 o'clock this Friday. Isn't it 5 p.m.? Because I think it's 8 Eastern. Yeah. And then she goes on to say, back to the case here. Plaintiffs have acted in good faith throughout this lawsuit to attempt to stop defendants from destroying their business, reputation, their personal relationships, and defendants have failed to properly answer the lawsuit. Yeah, I'm gonna agree with that. Throughout this entire lawsuit, it has been Katie Joy continually trying to ruin the reputation of 7M and destroying their business. She still does it, even during the lawsuit. As defendants' time to answer this lawsuit has passed, which is true, and they have not shown a reasonable excuse for this failure or other reasonable defense to the lawsuit on its merits, the court must grant plaintiff's motion to default judgment against the defendants. Accurate. Again, Amber is really matter of fact. She's really down to the details of the facts of the matter, right? She's not pulling any punches. She is adding her opinion in here that they have failed to meet a reasonable defense. Sure, that's fine. But the fact is that the deadline to file the answer had passed, and the answer was filed late. There's no excuse for it. There's no reasonable excuse for it, because a family emergency from a lawyer that did not even do the answer is not an excuse. Saying that you didn't know the rules of civil procedure is not an excuse. Now, however, to play devil advocates. Oh, is it listed at 6 p.m. Eastern? I'm gonna have to look into that. I don't remember Kimamaki. Let me look into that. I will get back to that. I thought it was supposed to be 8, but I'll look. But to play devil's advocate, the judge could say, okay, yeah, you know what? You lawyers messed up. You missed a deadline because you didn't know the law. That's your fault, but your client shouldn't have to suffer for it. Your client shouldn't have to suffer because you had a family emergency. She might do that, and she would probably be well within her rights to do that, because it was the lawyers messed up. It was their fault and not the client's. However, on the flip side of that, Katie Joy has been going around lying, saying that they didn't mess up, that they didn't miss a deadline, and continually to defame their clients. And there has been no reasonable, articulable
evidence and reason why Katie Joy didn't commit defamatory actions against their clients. There's been nothing. They have nothing but it's just First Amendment. No, it's not. So the judges might say, you know what? This is all just nonsense. Clearly, there's been defamation that you have no reasonable excuse for. You missed deadlines. You're not participating, properly in the rules of civil procedure, and just grant the order, the motion for default judgment. However, I'm still going to go on record to say that the likelihood of a motion for default judgment being ruled is probably slim, because judges tend not to like them. Of course, they want things actually to be adjudicated on the merits. But with all things holistically taken into account, because of what Katie Joy has been doing, and the fact she still goes on to defame, she still goes on saying that there has been no missing of filing deadlines, she's actively participating in this ruse. Good night, Autistic Shell. Good night. Always a pleasure. Thank you for dropping by, as always. But what do you guys think? Do you guys think that the motion for default judgment would be granted or not? One, if you think it'll be granted. Two, if you don't think it's going to be granted. And three, you don't know. You don't have a position either way. You're agnostic on it. Yeah. I'm just going to say for right now, and hopefully I'm wrong. I really like to be wrong on this. But I'm going to say it's not going to be granted. I'm going to put 2. And if I'm wrong on that, I will be, oh my God, I'm so wrong. Thank God I was wrong on that. And be so happy that the default judgment was granted. But as it stands now, probabilistically, it just seems to me that there's much lower probability for the judge to answer the motion to give a default judgment with denied. So, in the alternative, plaintiffs file 3 discovery-related motions prior to the defendant's failure to answer this lawsuit. If the court finds default improper at this time, then the following are plaintiffs' replies, memoranda in support of discovery motion. So they're basically saying, look, if the court does not deem at this time a motion for default judgment, which I think is going to be the case, but if they don't find it, then we're going to be talking about the motions for discovery. Then we have reasons to, because at that point the discovery motions won't be moot any longer. And so they go into what's called the Dahlberg factors, and there's 5 factors. And I was reading up this about the other day. According to the Dahlberg factors, there's basically 5 major factors that have to be taken into account when looking at if you want to get a protective order or not, as far as the information being sealed. I'm not talking about a restraining order. I'm not talking about a personal protective order. It's not a PPO. This is a protective order about the information being released to Katie Joy and to the public, because they don't want Katie Joy having this information because she will weaponize it. And they've made a damn good case to the judge that'll be weaponized. Why? Because that's what Katie Joy does. All right. So real quickly, the Dahlberg factors are this. 1, first, defendants argue that the First Amendment completely prohibits any injunctive relief involving free speech. Protections of the First Amendment are not limitless. This is well established. You don't have the right to say anything you want without repercussions. Certain types of speech have traditionally been excluded from the First Amendment. This is absolutely true. There are several delineating exceptions to the First Amendment protection, which as obscene speech, fraud, speech integral to criminal conduct, and defamation. Yep, which his client did do. So they basically, I'm not going to read the details here because it's just long and I'm tired. But they say that Dahlberg factors include: 1, the parties' relationship; 2, the harm suffered to the plaintiff, that his request is denied, compared to the harm suffered by the defendant if the injunctive relief is granted; 3, the likelihood of success of this marriage; 4, public policy; and 5, the administrative burdens of enforcing the order. The big one, I think, on here, if they have to take all factors, right? All factors to say, should I grant a protective order? The parties' relationship, well, it's a hostile relationship, obviously. It is a relationship where you have a malicious gossip columnist lying about their clients. That's the relationship. But 2, this is the big one, I think. The harm suffered to the plaintiff as opposed to the defendant. Who is suffering more by Katie Joy lying about them? And if this information got out, who would suffer more? It would clearly be 7M because Katie Joy would weaponize it. That in and of itself is a massive reason to grant this protective order. Again, you have to take all the Dalbeck factors into account, but that's a big one. I think that is one of the biggest ones there, and I think that's what the judge is going to give most weight to. If they don't give the protective order, will it harm 7M? Yes. Hi, Lawrence. How are you tonight? Welcome. The likelihood of the success of this marriage. Well, the defamatory case is pretty strong, right? And, of course, administrative burdens and public policy, and not really a big deal. But she argues that the balance of harm favors the plaintiffs, because if they don't grant this, there's going to be damages. There's already been damages by her releasing information about other people. I mean, she's done this before. As outlined in plaintiff's memorandum of law and supporting affidavits, they've already lost millions of dollars due to defendants' smear campaigns against them. Yeah. Katie Joy hasn't lost anything. She needs to. She needs to lose $1 million. Defendants have failed to address the irreparable harm already caused by them at the expense of the plaintiffs, and instead focus their argument on how it is a harm to them if they're no longer allowed to monetize and false and defamatory statements they have been making. Yeah, Katie Joy's excuse is, I have a right to make defamatory statements. I have a right by free speech to lie about your client and make money off of it. No, you don't. And it's somewhere in here. I don't know where it's actually at. Maybe it's in the other document. But it actually even states that Katie Joy's own inability to recognize the fact that she has caused harm and things of that nature is reason enough to have a protective order. So, hi, Lady Firebrand. How are you? Greetings from Australia. Nice. Love Australians. Hang on one sec. Yeah, it's a reasonable time for you guys, isn't it? I slept today. I slept a little bit. It was my day off. I decided to take a little 6-hour nooner, and oh man, I needed that. So I would have streamed earlier, but I like these late night streams because they're a decent time for Pacific time. They start about 8 o'clock or something like that, or even 10 o'clock if I'm getting off work. It's not too late for Pacific or Eastern even, because a lot of Eastern stay up like 2-3 o'clock in the morning, and then of course you have Australians and European people getting up early. But yeah, I like this time too, actually, to stream. And then she goes into the other factors. I'm not going to get into all that. But she says, defendants in the memorandum of law opposing plaintiff's motion for a protective order have failed to show a legally cognizable reason plaintiff's motion should not be granted. In fact, counsel's failure to recognize how their own clients' behaviors and statements are... this is where it was. In fact, counsel's failure to recognize how their own clients' behavior and statements are or could be construed as potentially leading to the public dissemination of highly sensitive information supports plaintiff's notion. Snark! Basically, she just outright said, hey, your client's too stupid to realize her behaviors are harming people. Which is true. I would take that as snarky, right? Counsel's failure to recognize how their own clients' behavior or statements are, or could be construed potentially leading to public dissemination of highly sensitive information supports plaintiff's motions. And by the way, she's actually talking about the counsel's failure to recognize. She's saying that the counsel has not recognized that Katie Joy's behavior could do this. And even though somewhere else, though, I swear I thought it was something about Katie Joy doesn't recognize it either. But that's a kind of a given, right? Katie Joy clearly doesn't recognize her own behavior. She's so lacking of self-awareness is beyond measure. But here she's actually giving snark on the lawyer. In fact, counsel's failure to recognize. That's pretty snarky. I like that. Defendants argue that plaintiffs have failed to show good cause exists for the issuance of a protective order. This allegation is supported merely by the defendant's belief that the posts, which are the subject matter, were not proper in the first place. Something I wanted to look at. I thought there's something else, but maybe it wasn't this document. Let's see here. Plaintiffs have specifically alleged that defendants have previously disclosed documents which were private, sensitive, and in some cases subject to protective order. As outlined in defendant's memorandum, this disinformation of documents obtained during the court proceedings or subsequent misstatements of fact and law about those documents are partly why plaintiffs are requesting a protective discovery order in this matter. And I think they will get this. These statements are contrary to fact. Defendants have consistently and mercilessly posted filings from this case, letters between counsel, and have posted depositions from other cases and misconstrued what documents state. And yes, Amber is aware of my lawsuit with Katie Joy, obviously, and she also knows that Katie Joy has lied in that lawsuit. Shocking. She knows Katie Joy will misconstrue things. If I have to be called as a witness to show that she has done this in other cases to get the protective order, I would be happy to do so. You know, because Amber has seen the documentation from my lawsuit with her. You know, so yeah, she's well aware that Katie Joy does this, and there's evidence to be had that she's done it in other lawsuits. In addition to defense near constant posting of court documents and other things obtained through the lawsuit, she has also reported weapon in an upcoming proposed documentary. Man, releasing that was pretty silly because that's going to be used against Katie Joy. Again, this is why clients say don't say anything, because now that it's out there that Katie Joy can weaponize it, there's even more reason to grant a protective order. Due to the nature of the lawsuit, confidential information already disseminated by defendants egregious lies about the plaintiff, and irreparable harm already bestowed upon plaintiffs and defendants' involvement in a documentary about plaintiffs respectively request that relief requested in the memorandum of law be granted. And then they go into amended scheduling order and stuff. I think that the protective order will be granted. I think there's absolutely sufficient cause for it. I think this is the same one. Yeah, the same one. Anyways, that's the documents. That's my 2 cents on it. What do you guys think? Anything before I go here? I just wanted to give you a quick my take on it. If you have any questions on it, I can answer to the best of my ability. But again, I'm not a lawyer. These are just my hot takes. But I think I'm pretty close on it. If you guys know more about it, then you're more than welcome to join. If not, just talk to me in the live chat or leave me a comment in the comment section. But I think I've did a pretty good assessment on it. What do you guys think? Am I way off the mark, or am I close to hitting home that Amber is being a lot more fact of the matter, Graham is being a lot more emotional, and letting his own personal positions creep into the lawsuit. Graham is being incompetent in many ways. Graham not knowing the rules of civil procedure. Graham trying to use the excuse that he had a family emergency, got the name of the person wrong, or the not really, it didn't get the name, but the familial relationship he got wrong, right? It's either mother-in-law or father-in-law, which is pick a lane. And then saying that, oh, well, we don't need to file answers because we're waiting on this, that, and that, and yet the deadline doesn't matter. The court has disagreed. I think the court says, yes, you needed to file an answer, or at least the lawyers have said, hey, look, you needed to file an answer. You didn't file one. We're filing for default judgment, and let the court rule upon that. Now, again, I find it very, very doubtful that they'll get the default judgment for a multitude of reasons that I gave. I'm hoping they do, because it'll just save everybody a lot of time and money. But at the same token, even if they don't get it, at that point we get to see Katie actually go to court, which would be great too, right? So it's kind of win-win either way. Even if they grant the default judgment, it's over, it's done. Katie loses $1 million, and she can basically lose everything, lose her channels, lose her car, lose her house. I don't care. She could be homeless and living on the street, and I will be having a party. As long as her son's taken care of, that's fine. I'm sure that Katie Joy's husband would be happy to take her son and take care of him somewhere, or a family member. But I want Katie Joy to pay and suffer. I do. I admit that. I think she deserves it. I think it is justice. I think it is retributive, which I'm not generally mostly into retributive justice. I like to think that most people will be rehabilitated through restorative justice or rehabilitative justice, but there's still a need for some kind of retribution
retributive justice. And in this particular case, when you have somebody who's such a sociopath who will never learn by her actions that retributive justice is pretty much the only way you're going to get somebody to pay for what they have done. So yes, I would like to see Katie Joyce living on the street. You can quote me on that. I'm fine with that. I want to see justice served, and I want it to be retributive in this case. I want her to lose everything. So a default judgment will do that. She'll lose her money and everything else. But people argue, well, that doesn't mean she actually committed anything because she didn't, go to Kate's to have it, ruled upon. Well, yeah, but a default judgment is as good as saying we didn't have proper defense. We're not defending on anything. We agree that the motions for defamation have merit, and we're not defending it. Because that's what a default judgment is. A default judgment basically, for all practical purposes, says that everything that the alleging party is true. For all practical purposes, it does. But of course, many of us want to see Katie Joy lie on the witness stand. But we've seen Amber Heard did that, and what happened? Nothing. Amber Heard blatantly lied on the witness stand, and nothing happened. There's no freaking perjury charges. Kyle Curtis blatantly lied in his depositions. There has not been perjury charges, even though the detective says it's ongoing. I have not seen anything come out of that. So, yeah, the chances of anybody getting busted for perjury and lying under oath seems to be nothing in the state of North Carolina. North Carolina, I will go on record to say, doesn't seem to give a shit about perjury, and neither does many other states. Like Minnesota probably doesn't give a shit about perjury if Katie Joy goes on and commits perjury under oath. I just don't think they care, because the perjury in a civil case is almost unheard of. So would we like to see it? Would she suffer on the witness stand? Yeah, sure. I'll watch. I would enjoy every minute of it. And then she can lose $1 million or more, and I'll be very happy. So either way, it's a win-win. I'm just at the point just be done with it, get the default judgment, move the hell on, let her lose everything, and game over. Because I'm sick of hearing her name. I'm sick of listening to people talk about her. But the fact that we are all involved in it because we have a personal vested interest in it and a personal stake in it, I get why we do it. But I still rather have the default judgment just because it's over with. But if not, whatever. But if the default judgment is not granted, I do think the protective order will be granted, which will preclude and prohibit Katie Joy from using anything that she gets her greedy little witch hands into for dissemination to the public, or be using any kind of Netflix documentary. They wouldn't touch that if they know that if it's confidential, right? So that would be fine too. But anyways, looking at the live chat, Lady Firebrand says, I have a special contempt for brain deficient nutbars like her that throw out sexual harassment accusations. Absolutely. And I appreciate that. I really, really do. I know you, Renelle, Aaron, Tina, Mia, and many other find her allegations to be so morally reprehensible that she just throws them out so cavalier-like, that she has no compunction to lie about men or even women for that matter. But I mean, she will lie about things with impunity, especially when it comes to sexual harassment, which never freaking happened. We know that never happened now. There's just no doubt. I can't imagine anybody having doubt on that. But if they do, they can come talk to me about it. I'll be happy to have a conversation with them and show them all the evidence Katie Joy lied. But so far, nobody has taken me up on that. Not a single person has said, oh, I think that Katie Joy is telling the truth. Can you talk to me about it, Steve? No, not one. Not one. At least I can't. I don't remember anybody. If there has been, I can't recall. I'm getting old. But I certainly don't recall anybody doing that. But she says not only it almost ruins people's lives, but takes resources away from actual cases of this type. Absolutely. It harms actual victims. But Katie Joy doesn't care about actual victims. That's the problem. She plays the victim. It's all about her because she's a narcissistic sociopath. It has to be about Katie Joy. She has no empathy for other people and has no consideration for other people. She doesn't care how it affects anybody else. It's all about her allegations and how it affects her and how she can monetize it and grift off of it and play the victim, which is exactly what she does. She doesn't give a damn how it takes resources away from actual victims. She has never been a victim's advocate. Maybe early on in her mommy blogger days, I'm going to grant that, maybe. But since she's been on YouTube, she's not been an advocate for anybody. Name one person she's helped. Anybody. Does anybody know a single person that Katie Joy has ever helped? I don't know any. The courts don't care about perjury. I just hope some of them doesn't settle and that she loses everything. I can't see them settling. There'd be no reason to, Chemo says, then for the man, the sneak of false sexual harassment never washes off. Even if proven absolutely innocent, he'll forever be a monster. Yeah, for the most part. But but in my real life, it hasn't affected me. Everybody that I know in real life knows what's going on because I made everything public. My Facebook has 5,000 freaking people on it. And I would say several hundred of those people I know quite well. And I talk to them frequently in real life. I have a lot of people that live in my town. They all know what's going on. And not one of them ever questioned my sincerity. They loathe Katie Joy. They loathe Katie Joy just as much as I do because they know me. So it hasn't really affected me in real life, but I mean online, sure. But look at the people that do believe it, Chemo. Those people that believe Katie Joy, who gives a shit about them? They're evil. They're malicious. They're sociopathic. They have no ability to reason or to use facts and evidence, nor do they care. They're just trolls. So who gives a shit about them? It doesn't matter what they think. And yeah, I kind of had to learn that the hard way a little bit too. I admit that. It's a learning curve. I was offended by what Katie Joy had been saying. Of course, like anybody would. And I wanted justice. But here, and by the way, fun fact, yeah, it was, Mia is the one that helped me convince me to take it further. Mia Nova. It wasn't on my own accord. She talked me into it, and I thanked her for it, and I still do. I have no regrets. Even though it did cost a lot of money and I'm out of pocket a lot of money. You know what? I still think it served a purpose. I still think that it proved Katie Joy lied beyond any doubt, and that's what I was going for. Maybe I never will recoup all that fundage, but you know what? Life isn't always about that. And I try not to dwell on it. I don't like having unhappy, miserable thoughts about how other people have affected my life. And I've moved past that, and I'm enjoying my real life. It's so funny. I'm not even joking. Last night at 3 a.m., I had one of my ex-girlfriends that, I was really in love with at the time from back in the early mid-90s hit me up that I haven't spoken to in, I don't know, God. It wasn't. I'm sorry. It was 2003 we dated. I'm sorry. It wasn't. I'm off by a decade. Holy shit. My bad. People are going to be like, oh, look, Steve lied. No, I corrected myself. It was actually 2002 and 3, I think, when we dated. But it's still been 20 years. But I haven't spoken to her in God, probably 15, 16 years. Last time I spoke to her, we took a trip to Vegas together. And that had to be around 2005, maybe? Give or take. So it's been a while. But anyways, like I said, she just messaged me out of the blue. Wanted to know how I am and wanted to catch up and have lunch and stuff like that. And I'm thrilled with that. But she would never in a million years believe that I sexually harassed somebody. Never happened. Why? Because she knows me. We went out. And so I have to keep reminding myself, I have honest to God real people that know me and know my personality and know that it would just never happen. So Mian says she's the most despicable person I've ever met across, including in my real life. I agree. Well, it's almost a toss up at this point, Maya. Her and Uni are the two most despicable people in the world, but they're basically the flip side of each other. He's like the very effeminate version of her, and she's the masculine version of him. They're very, very indistinguishable from each other nowadays. They're so much alike. So if I really had to put money on who's more despicable between Katie Joy and Uni, I'm only going to go with Uni. I'm sorry. I'm only going to go with Katie Joy only for the fact that her harm causes more in real life damage. She has harmed more people in a more egregious way with all these lawsuits than Unirock has. So I have to go with Katie. So yes, I will have to say that Katie Joy is the most despicable person I ever ran across in my real life or online as well, even though I've never met her in real life. But yes, I agree with you. I can't think of a single person in my life that I have detested and loathed and thought such a absolutely bankrupt a morally bankrupt person than Katie Joy. I can't think of any, you know. And I don't think we're the only people that think that way. I think there's a lot of people that have followed this and said, yeah, man, I don't know anybody worse than Katie Joy. So anyways, guys, I'm going to wrap this up. I want to thank you guys for watching as usual. Again, I'll be having late night hangouts after work, just like this. They'll be happening at 10 o'clock. Although we are going seasonal, which is going to be later hours, which will be 11. But, you know, as time permits, I'm going to be doing these types of streams. I'm also going to be doing 1 or 2 streams during the daytime on my next day off, which was today. And I was going to do a stream earlier today on existence, but I was just too tired. I needed a day off to recuperate. I'm entitled to that, I guess. But I still want to do that. So I'll still be talking about philosophical stuff. And then on Friday, make sure you tune into the Non Sequitur show to watch Red's Rhetoric become a Christian again in real time. That's going to be awesome. So with that, guys, I'm going to bid you guys adieu. Let me know what you think in the comments section. Let me know if you think that my really, you know, shooting from the hip analysis is okay. That if I got factual information correct, anything I didn't correct or didn't get correct, please correct me. I'm happy to take correction on that because, again, I don't follow the lawsuit as intensely as some other people because I just don't have the time, but I try to catch up when I can. You know. So, Lady Firebrand, thank you, Steve. I shall be having a double malt, and cheers to you. Absolutely. Enjoy that double malt. I'm still drinking coffee, although I got beer in the fridge, but it's just not a drinking night for me. But I really do appreciate all you guys that came by to listen. And like I said, do me a solid. Please leave me comments. I know Anis Frida leaves a lot of comments, and I appreciate every one of those. Love them. Keep that up, Anis Frida. I love your comments. Seriously, they're always of interest. But I like to see some other people comment as well. So I want to get their opinions. So Maya Noma, Kimamaki, Lady Firebrand, and other people that listen to this later on, leave me a comment in the comment section. Just give me some feedback. I like reading those. Those things I do enjoy doing. So with that, I bid you guys good night, and I will see you on Friday on the Non Sequitur Show. Good night.